welcome to our show. I'm your host, Melissa Ridgen. It's an issue that's hogged its fair share of media spotlight over the past year, but despite all the press, it's an issue people just don't get. An APTN Facebook poll showed 86% of respondents said they don't know what the Indigenous Rights and Recognition Framework is all about. So today, we're going to put that in focus. We want to untangle the jargon and talk in plain speak about what the federal Liberals have been working on, why some think it's moving in the wrong direction, and why even more people like myself are kind of scratching our heads about what it all means. We want you to join in our conversation, though. Our phone lines are open. You can call us toll-free at 1-877-647-2786. You can also tweet us at InFocus. Before I introduce you to our guest, let's set the scene. The federal government has been working on this Indigenous rights framework legislation since January. It's legislation the Trudeau government says would put Indigenous rights into law and stop the never-ending lawsuits tying up courts and money that First Nations and Inuit and Métis could be spending on other things like program delivery. The Minister of Crown Indigenous Relations, Carolyn Bennett, spoke to chiefs at a special forum hosted by the Assembly of First Nations dealing with rights held in Vancouver over the summer. The main subject of her speech was the recognition and implementation of Indigenous rights framework. But there are many skeptics who don't trust what the government is doing. In the fall, the AFN held a forum to discuss the government's proposed rights implementation framework. Ottawa wanted to table the legislation by Christmas, but the message from First Nations is to slow things down. So Todd Lamarand is going to bring us this report to make all of that make sense.
The Chiefs of Ontario and Association of Iroquois Allied Indians had a simple message for Ottawa.
Moving forward, we do believe that we have to do a hard reset on this process so that we can actually examine the best way to move forward together with the federal government.
There is no recognition of our inherent rights. There is no recognition of our international treaties. There's no recognition of how we're going to deal with land matters. There's no recognition of how we're going to deal with the provinces.
At the Assembly of First Nations Forum, that sentiment was not just limited to Ontario. Catherine Swampy is a councillor from the Samson Cree Nation in Alberta.
We want to reject it for the sense that we don't trust the government. I mean, history stands, and why should we trust the government? They've really given us no reason to trust them.
The day before, Crown Indigenous Relations Minister Carolyn Bennett promised the government would listen, but still within a deadline of getting legislation tabled in December and passed before next year's election. The Chiefs of Ontario still believe that may be possible.
Absolutely. If they have the political will to do something, we can get it done. We have the political will on our side of the table to be able to move forward on a positive, constructive basis.
National Chief Perry Bellegarde believes the Framework Initiative won't get done until after the federal election.
But you can't rush that, and you can't get it done in 2 months. That can't be done in 2 months. So the message that I'm hearing from First Nations is slow it down and do it right.
The chiefs at the press conference are under pressure to get it right.
Because what this is attempting to change is changing it forever. We'll never get another shot at being able to change something in the context of where they're going right now.
As well, Swampy needs time to educate her community members.
They don't know about any of this stuff that is being pushed on us because they're just worried about their survival. You know, the government keeps us in such a state of poverty.
Treaty 6 Grand Chief Wilton Littlechild had an interesting idea. First Nations should draft the legislation and then present it to the federal government, rather than the other way around. Todd Lamarand, APTN National News, Gatineau, Quebec.
Okay, so let's follow that up with a little bit of Framework 101. This is according to the federal government on their website talking about the need for legislation to change the Crown's relationship with Indigenous people as a much needed part of reconciliation. It says, this is what it says, I'm reading off their website. It says, whatever legislation is passed will create new tools and mechanisms for supporting self-determination through both law and policy support, distinctions-based approaches to First Nations, Inuit, and Métis, advance the implementation of treaties and agreements, support new approaches to the evolution of treaties and agreements, and it will keep the Government of Canada accountable. The government says what this will not do, what legislation will not do, is define and limit the rights of Indigenous people, create municipal-style governments, infringe on provincial or territorial jurisdiction, which is an interesting part we'll have to unpack later, and alter without the agreement of all parties, any treaties, agreements, or arrangements concluded under existing policies or tables currently operating under existing policies. preclude Indigenous people or provinces and territories from pursuing other opportunities to advance their priorities. It also will not extinguish the rights or seek cessation, release or surrender rights, or impose solutions. So as much as we're just talking about not having any jargon, we have some more jargon in the explanation about jargon. So I'm joined now by Nigan Sinclair. He is an Anishinaabe from Little Peguis. He is an assistant professor at the University of Manitoba, currently on sabbatical. And he's a regular commentator on Indigenous issues on television and as a columnist at the Winnipeg Free Press. Thank you for joining me.
Great. Bonjour. Hello.
So where do you even start with a giant, messy balloon that this kind of this framework is? We should say too. So the government has hit pause on this, but if you were to say to people who say I have no idea what this is, where do you start the explanation?
So to understand this move by the federal government, you have to understand a long history, and it would be impossible for me in the few minutes we have before we move on to other concerns about this legislation. But the basic premise of what you need to understand is that since Canada's Confederation, Canada has sought to control, extinguish, exterminate rights of Indigenous peoples, which they have recognized as a part of the Royal Proclamation of 1763 and moving forward. And ever since that position, the government has tried to fit within their legal boundaries and frameworks to recognize Indigenous nations in sort of a limited way, giving us things like title or recognizing us title, and then eventually exterminate all the way going to the culmination of the 1969 white paper, which says we have no more rights, we're extinguished, we're erased, which we resisted fiercely, bringing us to the 1982 Constitution,
right,
which we affirmed and fought with many court battles, also marching in the streets to have Canada recognize Aboriginal and treaty rights. Now, to understand that means that the government intentionally or otherwise left that vague. And that section of the Constitution, Section 35 as it's called, is vaguely determined, or what the government has referred to as kind of an empty box, which will be determined at later discussions, meetings. But what has happened since is those meetings never amounted in much. And it resulted in a long march of our nations to articulate what our rights are to Canada through Supreme Court decisions. And these are costly, timely, take millions of dollars. And for every court decision, we get like an inch more clarification in rights, maybe a couple inches, but then oftentimes, sometimes marked back, because the Supreme Court generally comes and goes with people who have various knowledges of Indigenous rights.
Well, and so do governments, right? So, I mean, you could have a court decision, but then you've got a new government, and then it falls somewhere on the priority list depending on who's in government. So there's a lot of balls in the air.
So in the meantime, Canada's march towards trying to extinguish our rights continues. Every time we march and we fight something like this 1969 white paper, all they do is they just break that up into different parts and then try to get out of the Indian business, as it were.
Right.
And by extinguishing our rights to, for instance, parenting our children, whether it's the residential school, now it's the child welfare system.
Yeah.
So to understand all of that, though, is the government understands our rights as something that to be articulated later, like an empty box. Something that we claim fundamentally different, which is that we have what's called inherent rights and sovereignty, which predates Canada.
Right.
We have rights or practices, traditions, our languages, for example, which we have continued both at Contact, Confederation, and continue to have today. But Canada wants to take those rights and articulate them, have them sort of TBA, like to be determined later, or TBD. And that's very costly. So what's now the Trudeau government's trying to do is hold forums and discussions to try to settle that issue, to create what Minister Bennett has called a code.
Right.
And that code then articulates what our rights will be. But there are so many fraught problems, most of which being the speed in which they're operating.
Well, and who's driving the boat, too, right?
Well, of course. I mean, who gets to speak at the table? You know, the concept of one set of guidelines of code of rights that affects every First Nation is a long-standing technique of one set of rules for everybody. It's called the Indian Act, which has been fundamentally a problem in all of us, because all of us, we have, how many different nations? 1,000 nations, 600 that are recognized, and so on.
And they've complicated it further, because they're not even just saying First Nations at this point. They're saying Métis and Inuit have been lumped in with this as well.
Right,
so
yeah.
the layers of dysfunction, or as you said, fraught with peril, there's a lot of them.
So this federal government, just to boil it down to understand what this current framework is they've met with approximately 1,600 or so, what they're claiming, participants, 100 engagement sessions, over 100 engagement sessions, to say this is what we've heard from First Nations peoples, leaders, grassroots people, so on and so forth. And then they've come up with, they presented, Minister Bennett presented to chiefs in September, October, in the fall. Here's what we found out. And what's been unveiled through that is that things like inherent rights, all the things that I talked about with the full box, things like in sovereignty, that we have a right in which to determine for ourselves how our governments operate, how our languages should be delivered, how we should have relationships with land. Those things are almost absent within those that framework, that code that she's talking about. And so while they say things like we will not create municipal governments, the way that it is looking is that our rights will be severely limited by this. This code will limit our rights. And once again, here we are giving up things, giving up our rights, allowing the government to dictate to us yet again, time and time again. Even, none of us wanted 2-3 ministers of Indigenous affairs, and now we have them. We weren't consulted in any of that, and this government's acted in much the way most governments have in the past. They will dictate to us the code, and then we will have to resist, fight it, talk about our inherent rights and sovereignty. There are so many issues. One of the biggest issues is, of course, what you alluded to, which is that the federal government said this is not going to impede on provincial jurisdiction. Well, what are all of our rights about? All of our rights are about things that the provinces claim to be theirs. Things like resources, things like parenting our children, things like justice, things like education. These are all provincial jurisdictions. So to say that First Nations suddenly will have a right over that, well, then what do we look like? Are we going to be a third order, or what people have said, a fourth order of government? And that, of course, looks like a municipal style under the jurisdiction of provinces, which we have fought tooth and nail to ensure have not happened. Our treaties are with the Crown. Our treaties are not with provinces. Right.
My question, do you think that is it well-intentioned that this government is even looking at this? I mean, if you take away the flawed logic, do you think that it's good news that this government is even paying attention and wanting to solve this? Because previous governments, as an onlooker, I would say previous governments maybe have had no interest at all. So is this better than no interest? I don't know. I ask you.
The way that I often tell people, or try to explain what I see this government doing, is this. I was at the final event of the Truth and Reconciliation Commission, a final report where the 94 calls to action. Of course, my father was the head of the commission. So
right, Murray Sinclair.
I was very close with the commission, understanding what it was all about. And I saw Prime Minister Trudeau smudge. And I said to my family, I said, that's pretty interesting. I'd never seen a prime minister smudge, or certainly in my lifetime, or maybe I'd been present to. I said, does he know what he's doing? And my family said, I'm not sure. And then he came up and he immediately committed to the 94 calls to action. And I said, because that means he committed to the United Nations Declaration on the Rights of Indigenous People. That means the Indian Act is gone, because the Indian Act is the most draconian controlling document in Canadian history. Oh, and by the way, the Constitution then is changed if you adopt the 94 calls to action, because you don't have control over Indians and land reserved for Indians. So I said to my family, this is a pretty momentous day, but what has happened since? So that says to me that he doesn't understand smudging. He doesn't understand what he's committing to. And what it says is that the people around him who are advising him are telling him that he's doing that, but he is not doing that. So when I see language like we will not adopt municipal-style government, I think he truly thinks he's not creating that, but he is, which tells me that there's a problem fundamentally in the way he's understanding the issues, but also the ways in which the people around him are counseling him for these issues, or perhaps in a more darker way. Maybe they actually are intending the same process of extinguishment, of termination, of assimilation that Canada has been engaged in for 150 years.
Well, I don't like either option is a little bit, it's hard to get excited about. Okay, we're going to have to take a break, though. We will be coming back, and the Association of Iroquois and Allied Indians is going to join us. They're holding a rally on Parliament Hill on December 4th in opposition to this government's plan. Later in the show, we will also hear from Chief Perry Bellegarde. He's going to weigh in, so stay with us. We'll be right back. Join our conversation now. You can call in toll-free at 1-877-647-2786. Like and watch us live on the APTN News Facebook page. Follow and tweet us at APTN InFocus. And send your thoughts in an email to infocus@aptn.ca. Welcome back. We are going to go to social media now to hear what some of you are saying about today's topic. Do you think Canada needs to replace the Indian Act? Go to Steve. Yes, to the extent that Indian status causes confusion and division between Natives and other Canadians. We've got Ronnie. How about we replace the entire Canadian bourgeois democracy that was created by rich white men from England? Unless you were doing that, nothing is fundamentally going to change. It's an interesting point. Peter Howard says, I'm sensitive to the concerns of our First Nations, but I do not consider my own opinion about the Indian Act to be informed enough to answer that question. How do First Nations feel? That's a good point as well. People should be asking, well, it does affect all of us, but First Nations especially. Indigenous people should write our own laws, not some suit-wearing guys in Ottawa. And Sherry, Canada can keep all their upside-down laws and just give our lands back already. I don't think that's going to happen. We would still like to hear what your opinion is. If you want to join our conversation, here's how. Join our conversation now. You can call in toll-free at 1-877-647-2786. Like and watch us live on the APTN News Facebook page. Follow and tweet us at APTN InFocus. And send your thoughts in an email to infocus@aptn.ca. So the federal government's Indigenous rights framework legislation has been delayed, and it won't be coming before the end of the year. APTN's Ashley Branson spoke with some Indigenous leaders in Manitoba for a regional reaction. Let's look at that. Oh.
Last February, Prime Minister Justin Trudeau promised legislation he would recognize Indigenous rights and put them into action. But many First Nation leaders have concerns about it being rushed and what the framework would mean. On a recent edition of APTN Face to Face with Dennis Ward, Crown Indigenous Relations Minister Carolyn Bennett tries to ease concerns some have over a potential loss of sovereignty and rights under the framework.
No, we want them at the table and a lot of them are at the table. I mean, a lot of the people who have been critical are also at a table negotiating the implementation of their rights. And I feel that just like the Prime Minister says, that everything we do now is based on the recognition of rights, respect, cooperation, and partnership.
The Assembly of Manitoba Chiefs Grand Chief Arlen Dumas is relieved to hear of the delay. He says in order to move forward with the legislation, it has to be done properly with meaningful participation from those involved.
It's difficult when you actually see the bureaucrats of the government incentivizing and directing resources to already prescribed solutions. So it causes difficulty because then there's a question of the motives of why there was such a desire to rush this issue. So that's why I'm very pleased that it's going to allow for more time to have meaningful discussion.
But President of the Manitoba Métis Federation, David Chartrand, fully supports the government's legislation. He says he'll push for the Indigenous rights legislation to continue as planned.
We're ready, and we should not be held back because First Nations have a larger base, of course, across Canada that they have to worry about, and they already have these legislations, comprehensive land claim. They already have most of this stuff. We have zero. So from our perspective, I think it's a message we will give the Prime Minister in Canada. We want to move forward on this directly as the Métis, distinct with the Métis Nation. And when First Nations are ready, they can come and do their own. But we're ready to do ours.
Ashley Branson, APTN National News, Winnipeg.
Earlier this week, Face-to-Face host Dennis Ward sat down with Minister Carolyn Bennett. They touched on the rights framework. Let's take a look.
And Minister Bennett, I'd like to move to the so-called federal recognition and implementation of rights framework. What is it about this legislation that the government is wanting to move forward so quickly with?
So a framework is two things. It's changes in policy as well as deciding what needs to go into legislation. So the policies that have been criticized as long as I've been in this town, the comprehensive claim policy, the specific claim policy, inherent right policy, those have to change. And so whether it's getting rid of cede and surrender and extinguishment and all of those things, those were great deterrents to people entering the path to self-determination. On legislation, there are some things that that the groups who are already self-determining, self-governing, have asked for. Changes to the Interpretation Acts in terms of non-derogation, but also the call for some better way to do dispute resolution than ending up in court every time, but also what was in 3 of the articles in the UN Declaration. There they call it treaty violation, but we've been asked to put in place a oversight body for treaty implementation that is, did Canada do what it said it was going to do when it signed an agreement? And so those are the things that the self-governing nations asked for in a letter to the government in 2014. So those are the things that we think, and we are being told they've waited long enough for. But also the Métis groups are very clear that they want some protection for the gains that they, so fought so hard for.
Joining us in studio is Nigan Sinclair. He's an assistant professor at the University of Manitoba and a regular commentator on these issues. He is also a columnist at the Winnipeg Free Press. And joining us as well will be from the Association of Iroquois and Allied Indians, Deputy Grand Chief Gordon Peters. He's in Toronto. He'll be joining us. First, before we go to our guests that are here, we want to take a call from Amelia here in Winnipeg. Amelia, are you there?
Yes.
Hi, Amelia.
Yeah,
what did you want to add to this?
Good afternoon to Nigan. I know your dad. I met your dad years ago when he started residential school meetings. Anyway, I want to say I'm 76 years old. My dad lived to be 100 years old, and I'm a Woodlands Cree woman, and I can't believe what law that we have to take the government to court to get our rights implemented. What kind of a law is this? Why should we have to take our government that's supposed to be looking after us, the court? So our resource, our treaty rights should be implemented. Why? That's not our government. And the treaty and the people in Ottawa, that office there that's making decisions for us, that should be wiped out. We should never have nobody telling us. We had our own already. My dad lived to be long enough. He told me lots of stuff before he died. We already had it.
Thanks, Amelia. We're going to let Nigan answer that.
So miigwech, Amelia, for that comment. I can't agree more. We have our rights and we have our nations. We should just enact that, and then the government should just have to deal with it. But the problem, of course, is that they have, what they mean for the federal government, our treaty relatives in certain areas of the country, acts in particular ways in which they infringe or impose or and in times deny and exterminate our rights.
Yeah.
So then we're stuck in this relationship of dysfunctionality that often leads to arrests. So as much as we have a Prime Minister who's selfies with First Nations and Métis across across Canada. Then he tweets out the next day, we will build this pipeline no matter what, even though we make the claim, and the legitimate claim, that this is an issue of sovereignty and our inherent rights. This is not an issue of Canada gets to decide this. And when he running for election says we have inherent rights and sovereignty, but then says later that we have no rights or veto power, whatever he calls it, on our territories. This is a government acting in two very different ways. We actually have creation stories about this, in which we engage the newcomers with two sides of their face. And so we knew about this, and in many ways, what I say to First Nations when I work with them, and Russ Diabo and Pam Palmater and so many other incredible speakers, and that what they say and what I say is we should just enact our rights. And when we enact our rights, unfortunately, that may involve a state that refuses our rights. I think at times there may be an issue of a conversation that's ending. When I hear Romeo Saganash dropping a swear word in Parliament, I can see the conversation shifting to a very combative stance. And I think that's where this rights legislation will head, to a very combative situation.
Well, I think it needs to. Deputy Grand Chief Peters, are you on the line there? Can you hear me?
Yes, I am.
So what's your take on this? You've been listening for a little bit. Where do you stand on, well, for one, Amelia's question, but also what problems do you see within this framework, even though it's been stalled? Just
Let me tell you from the beginning, the presentation that was made by the Prime Minister, the words that are now being said by the Minister, they have no correlation to the actual documentation that's provided. In fact, right now, from the Standing Committee, this framework process is supposed to take in the 75 tables negotiating, it's supposed to take in Canada's 10 principles, and it's supposed to take in UNDRIP. So there's a lot of good words being said, but there's not a lot of good things in that are being written. When the process started, we said that we'd be happy to sit down with the Government of Canada, and instead Canada adopted its unilateral 10 principles. Those 10 principles do not create the same standard as UNDRIP, nor do they create any standards that are similar to ours that we would put forward in an established relationship. So here we are at a crossroads. They have provided all of this information. They're running around right now and they're trying to see if they can buy support out there. And we're in a situation where we think, look, we have these treaties. There is a distinct process that's there. The United Nations has said very clearly to Canada that if there's no unassailable proof that Indigenous people have consented to give up their lands or their resources or their rights, then they are still intact. Canada's position in this whole process is we don't have any rights. And so this process is about certainty. Not about anything else. It's about certainty. It's about certainty so that there can be never anybody in the way when Canada wants to exploit the resources, whatever they want to do in the context of national interest. There will be nobody to stand in their way. The notion of acknowledging and recognizing our rights. What happens is that we see the process right now because it's done through other agreements. What they do is they take that agreement that's signed with First Nations, they use the process of incorporation by reference, and they add the Section 35 to that. So when they're done negotiating, they sign that document. It means that they no longer have inherent rights, but they have Section 35 rights. That Section 35 rights, when it has extinguished that inherent right, it means that it still can be subject to change, even though it's a constitutional, is recognized as part of the Constitution by that incorporation by reference, but it's still only legislation. We want to get back to something that's more equitable. We want to get to the table and we want to talk to them about mutual principles so that we can move forward. We talked about a new royal proclamation that's in the Royal Commission on Aboriginal Peoples. We want to talk to them about removing some of the impediments right now that are hitting us over the head. The inherent right policy, we want to talk about the specific claims policy and the comprehensive claims, because in the claims process, we have to prove that Canada fraudulently took our land. We want to talk about the integral to distinctive test, which is the Vanderpeet test. We want to get rid of those 10 principles. If we got rid of some of those things, it would begin to balance the field so that we could have some kind of honorable dialogue. But there is no honor in the process being established by Canada today.
What do you say to that, Nigan?
Well, miigwech for all of that. There's a lot to unpack there.
There's a lot in there.
And what I would say is I just add in what the 10 principles that was mentioned is the 10 principles that were imposed upon First Nations by the government. And in a typical process, they came up with 10 ideas that they were, and most of them are good ideas. I think most things where First Nations were looking at, but of course they were imposed upon. Here's one of the conundrums that we're in now. The biggest issue, one of the principles that the government has adopted in their dealings with First Nations is that there will be free, prior, and informed consent on all projects involving First Nations territories. So we've seen that result in the overturning of the National Energy Board decision involving Trans Mountain pipelines. That was inadequate consultation. So now we've got a consultation process which the government has announced, and so on and so forth.
Yeah.
Here is the challenge: the government owns the pipeline.
Yeah.
They also appoint the board at the National Energy Board, so they will essentially be ratifying their own consultation process. They own all the cards, and we get to go and watch them play the card game. It is a situation fraught with issues, and this particular rights is the same situation. They're holding the consultation, they're coming up with the code, they get it imposed upon us, claiming to be adopted on the 10 principles, but as I've mentioned before, and as was talked about, this rights legislation is limiting rights. It's not a full box. It's not the full box that we envision.
Well, so, but it is better than what the status quo is. My question would be, just to play devil's advocate, do you take this framework as it is and say it's flawed, but we'll take it because it's better than the status quo, and then after you take it, then you work towards improvements because you've made a leap forward?
But
Absolutely not.
Okay.
This framework that's being proposed is not better than the Indian Act the way it's structured right now, because the Indian Act doesn't eliminate rights. Indian Act is a piece that starts to set out management and administrative issues. This now begins the elimination of our inherent rights. There is no consent that's being offered in the 10 principles. It says that the government will aim to gain our consent. That's consultation. They make a pre-decision about where we stand. They call it something like some kind of cooperative federalism, for example. I think that's the terminology they use. But no, definitely not. This thing is harmful. It's a threat to our inherent rights. It's a threat to our land rights. It's a threat to our future of our children, our economy, absolutely everything.
I'll just reiterate what Grand Chief Peters is talking about is that certainty that he referred to earlier. When this is imposed, the government will then act moving forward. As we've seen with the government, once a right is extinguished, they don't go back from that. They don't go back from that. The right to simply, the government's right or claim to things, like let's say, for example, that on some terms the government dictates to us we have to work with the province on issues involving resources, for example. They're never going to retreat from that.
Yeah.
And so this certainty that Grand Chief Peters is talking about is something that this is a black and white situation. We have to get it right from the outset.
Gotcha. Okay, I think we have to go to take a break right now. But when we come back, we're going to hear from the Assembly of First Nations National Chief Perry Bellegarde, an AFN Regional Chief, and we still will have Russ Daibo of the Idle No More group that opposes the framework. And Nigan's still going to be here with us, so stay with us. We've got lots more to discuss. Hello, welcome back. On February 14th, 2018, Prime Minister Justin Trudeau announced his plan to chart a new way forward for the federal government by creating a new recognition and implementation of Indigenous rights framework to enshrine Section 35 into law. This is what they said. But how they want to do it has caused some confusion and or has ruffled some feathers. At an AFN meeting in Gatineau in September, Chief after Chief raised concerns with Crown Indigenous Relations Minister Carolyn Bennett. Shortly after that meeting, the Fed said that they wouldn't introduce the framework legislation as planned before the end of this year and that a lot more work needs to be done. I spoke with National Chief Perry Bellegarde earlier, and here's what he says happened in Gatineau.
There really wasn't a framework. It was a discussion document that the government rolled up after all their consultation processes. They rolled it up into what they heard. But what we really took offense with is that it was a flawed process. It was unilaterally done. You know, I've always said it has to be First Nations led, First Nations driven, the rights and title holders to lead this. Because it's only the rights and title holders that will really determine the path of decolonization and as well the path for reconciliation. So it was really a flawed process.
So while he says that the process was unilateral and it was flawed, he credits Ottawa for hitting the brakes.
I'm really relieved that the government is listening. They're listening. And so let's take the time to do this right. But First Nations have to lead it. And that's the process we have to go embark on past the next term in October 2019 if they get back in. It's just a matter of doing this right, taking the time, because we have a relationship with the Crown. We have a treaty relationship with the Crown. We don't have a treaty with the Liberals, or with the Conservatives, or with the Greens, or the NDP.
So while it looks like Prime Minister Trudeau has floated this with the hope possibly that it would be his legacy, Bellegarde says there is no way that legislation will be ready for or will be ready before the next federal election.
We all want to get outside the Indian Act, but it can't be rushed. It's a process, and it's going to be done nation by nation, treaty area by treaty area, you know, First Nations by themselves dictating the pace of that.
Bellegarde also said that the AFN is going to embark on a public education campaign so people can get up to speed on what this legislation should entail and why they should care. And of course, he wants to put it in plain speak as well.
I think we've got to also say to our people that moving beyond the Indian Act is important, and exerting that right to self-determination and using that right, we always say, create our own laws, occupy the field, is so important as well. So the education awareness piece has to happen. So a more effective communication strategy has to be put in place so our people on the ground know what's involved with this.
Before we go to our guest, Russ Daibo, who's joined us via Montreal, we have Melissa, who is on the phone from Halifax. She has a comment. Melissa, are you there?
I am.
Hey.
Thank you for taking my call.
Well, thanks for calling.
Thanks. Well, I don't agree with the Indian Act at all. Now, I'm only 42, but I just have realized in growing up and being here in Canada, you know, that our rights are constantly and consistently being trampled all over. And I don't understand why we as a people keep letting people in Ottawa dictate to us what we can and cannot do. I don't understand that. You know, like there's mental health issues in remote communities that need help. You know, we have to help we can't depend on these people anymore. You know, we have to look within ourselves, within our own communities. And that comes with the chief's help and community help and ourselves. You know, we have to stop looking to Ottawa for answers, right? That's what I feel.
I'm curious to hear Nigan's response to that.
Yeah, I mean, the most revolutionary thing we can do is learn our languages, form the governments in which we want to be recognized as, or not even worry about recognition, really. I mean, we of course have a relationship with the federal government, but enacting those things, of course, is very difficult when we are suffering from dire poverty. As I've often said, it's almost impossible to set up a language program or have a discussion on how to form traditional governance when you're having the inability to feed yourself.
Yeah.
And so there are very real challenges. They have to go hand in hand with dealing with our situations involving poverty, but also rebuilding our institutions, fundamentally who we are, and then expressing that, enacting it. What's called, we use big terms like enacting sovereignty. What it means is that if we have a land claim, then we go and we recognize ourselves as having that, and we enact it. And it's may be met at times with some force, but I really believe that at time and time shows in this country, that's the way in which we've been able to get work done in this country, by sometimes taking to the streets and sometimes being at the board table.
Yeah. Well, I think there's something to be said for the federal government keeping people in poverty and scrambling to survive, because you can't organize when you're in that situation. Russ, are you with us?
I am.
Russ Dibo, thank you for joining our conversation. What did you hear what the point that Melissa had made up there? Our caller?
I did, and
what's your
thoughts?
thoughts?
And your other guests as well.
Good.
Well, I agree with her. We shouldn't let Ottawa dictate to us. That's continuing colonialism. You know, this framework is a colonial process. You know, I'm not surprised that, you know, 80-some% of the people that were in your poll didn't understand what the framework is about, because the Trudeau government's been operating by bypassing our people and misleading them for the past 3 years. It's been a top-down approach, using the national Indigenous organizations rather than bottom-up, talking to the rights holders, the people in the communities and nations. And as the minister has said, the framework is policy, not just legislation. And they basically have 3 tracks they're using. One is these new recognition tables that they have. That's where they're developing the new policy under, and those are secret. We don't know what's going on at those tables, but those are feeding into the legislation they want to pass. And they already have the existing comprehensive claims and self-government tables across the country that pre-existed the Trudeau government. And then specific claims, you know, the lawful obligations about breaches of treaty and trust funds and things like that. They were in talks, well, they are in talks with the Assembly of First Nations on those. And I understand, you know, they basically haven't addressed an independent claims process that they promised that they would do. So, you know, this whole framework is a colonial process. It is Ottawa dictating it. And if I can just say, we have to keep in mind that behind the Prime Minister and the ministers is the bureaucracy.
Yeah.
They're the ones that are developing the framework. And in January 2016, the Prime Minister appointed Michael Warnick as Clerk of the Privy Council. And he was Harper's Deputy Minister of Indian Affairs for 10 years. And he did all kinds of nefarious things to First Nations in particular. And there's a committee of deputy ministers under him and a committee of assistant deputy ministers under them. And they're controlling this whole framework rollout through the bureaucracy, behind the ministers.
So what needs to happen? You know, they've pressed pause now. So now you're part of a group that's working with, that's associated with Idle No More, committed to teaching about this framework. What do you guys say needs to happen?
First of all, I don't buy that there's a delay. In fact, your own reporter, Justin Brake, talked to somebody from the minister's office that said they want to keep their options open before the election. They still may introduce the framework legislation into Parliament. What they're going to do is they're going to gauge, you know, the opposition, the reaction, the no side, you know, just like they did with the Quebec referendum on separation. They're looking at the Indigenous issues and seeing if they're going to have enough people on the yes side to go ahead with it before the election. Right now, they're seeing the no voices getting louder. But even Minister Bennett said on your own network that there's people who are passing resolutions rejecting the framework who are at these recognition tables negotiating with the government at the same time. So I think that everything's still on the table here. We can't believe this talk that it might be delayed. I think that's being put out there by the government to undermine our movement against it, I think. And I just want to say one last thing. This is about international customary law about human rights, and it's about, you know, Section 35, which is really unfinished business. Because I'm older than Negan. I was around during patriation, and I was at the First Ministers' conferences, and I know that there was a Section 37 that called for a First Ministers' Conference on Aboriginal Matters that they held in 1983. And that term, land claims, that's not our term, that's theirs. They amended Section 35 in 1983 to say for greater certainty, land claims agreements that have been settled or may be settled are treaties within the meaning of Section 35(1) of the Constitution. So they added modern treaties in after that. But our historic treaties aren't being treated with any real recognition or status, including our pre-Confederation treaties, you know, in what's now Ontario, Quebec, and the Atlantic. So we need a reset. I think we need to continue with our education process, because I certainly don't trust the Assembly of First Nations being in charge of public education of our people, because They failed miserably for the past 3 years in doing that. So I think we need our own teach-ins and our own materials to be developed. That's what we've been doing, and we're going to continue to do that. And we're going to organize and mobilize.
Is there a lot of...
We're going to hit the streets.
Is there a lot of take-up in this as people, because it's an issue that a lot of people just look and go, it's too big for me to get my head around. I don't know what it contains. I've got to worry about putting food on my table, all the other things that people, and especially on reserves, have to worry about for living in poverty. But is there an eagerness to figure out what this is and how to stop it?
The feedback we've been getting, and certainly through a lot of the feedback we're getting on social media, is yes, the grassroots are ready. And I guess we'll see on December 4th, because we've called for a national day of action to support the rally on the Hill. If people can't make it to Ottawa, we want them to do something on the ground, you know, in the communities or even in the cities where they are, to show the Trudeau government that we oppose this, we want to reset, and we want them to start from the ground up with our people, the ones who have the rights.
Leon, did you want to weigh in here?
No, I first of all, I agree that Russ is older than me and has much more experience and has seen really some of the real nefariousness that I talked about earlier.
Yeah.
And has taught really my generation about the ways in which the government takes a large policy, and then if they don't get it through the first time, then they break it up and move around and move the chess pieces around. What I would just add into all that is that this movement to educate has to happen in a way in which when we talk to everyday people, that we both talk about the history of where this has come from, how this is part of a larger process, because I really believe that one thing that the Liberal Party has done very well is to fracture the support or the interest in which change happens. So there's a lot of us in our communities who think the Liberal governments their policies deliver on the words that they use.
Right.
And we have to understand that that is a very different thing. They say things like, we'll recognize inherent rights, we will implement a treaty, and those things we've seen are not happening. There's more limitations to rights. Their treaties are still continue to be denied. So that first thing. And then second thing is also to understand that we can do something about this. And we can do something about this in a very proactive way. Education is one way, but also demanding that our institutions represent us, that they represent our cultures and our traditions. Even the chief and council system is not a naturalized way of our governments. Yeah. So many, when I talk to so many of our relatives on First Nations, they say, well, that's chief and council's problems. I go, that's our way. Our ways is that it's everyone's issue. Yeah. And that all of us, it's all of our job to enact our governance systems, because we are part of clans, we are part of families, we're part of kinship networks, and that we are all part of this governance system. We all are leaders. There's no such thing as a chief and council system in our traditional governance. There's a system in which we had leadership changed, grown, everybody shared a role in that. And if we're going to enact that, that means that everyone's got to come on board, that everyone's got to be a part of it.
Russ, you've said that this moving forward would be a threat to our survival as Indigenous nations. What's your group doing to make sure that that doesn't happen? Quickly, we're getting towards the end of time.
Well, we're going to continue to organize and get our people mobilizing. You know, I don't know, Moore has done it before in the past. I'm pretty sure if the people understand what's happening, they're going to get organized and defend their rights again. But I want to say that the reason I brought up the Constitution is because Section 37 said that we were supposed to negotiate what Aboriginal treaty rights means in Section 35. The governments ran out the clock on us, and it failed, but it's still unfinished business. And you notice the Prime Minister announced he's having a First Ministers meeting December 7th, right after the AFN Special Assembly, and then he's meeting separately with the national Indigenous groups to talk about economic development. You know, we should have a bottom-up process with our community people selecting our leaders that we want to sit down with the federal and provincial governments, because nowhere in this framework legislation they were proposing are the provinces. This is all based on existing reserve lands, and they're saying if you touch anything to do with provincial jurisdiction, they have a veto.
Yeah, well...
Yet we don't have one for free prior informed consent.
That's right. You got? Do you want to? We've got a couple seconds left.
I'm happy to. I mean, everything Russ is talking about is a constant dictation to us from the federal government. Long-standing, 150-year-old tradition. The tradition in Canada is to dictate to us how it's going to go. But we haven't accepted it in the past, and we have to continue to not accept that as a process. That's natural.
Okay.
Except this government promised not to change that.
Yeah, exactly. Yeah.
Okay, well, we're going to keep following this. People can give us a quick, where's the demonstration on December 4th at Parliament Hill? What time, Russ?
My understanding is at 11 a.m. It's the Association of Iroquois and Allied Indians that are organizing that in support of the youth who are opposing the framework.
Okay. So that's all the time that we have for today. I hope we've made a little bit of sense of this massive, complicated, boorish topic, rights and recognition framework. This episode is going to be available for download as a podcast on our website, aptnnews.ca/podcast. You can watch all the other shows that are on there as well. I'm Melissa Ridgen. Thank you so much for joining me. Have a great rest of your afternoon.